Good morning and welcome to this session of the Florida Supreme Court. The first case on our docket today is Thach versus the State of Florida. Counsel? Certainly.
The court consider evidence presented at the trial when determining whether a midtrial admission is prejudicial. We think not, that the determination of prejudice shall only be based upon the allegations within the information that was what the defendant must draw on, not the evidence presented at trial. Because the issue is, was the defendant given notice of the charge prior to trial, not whether the amended charge could be based upon the evidence presented at trial. As the analysis that the trial court and the DCA was made, they considered the evidence at trial, not the information that the defendant must find on. Molestation is not a of either charged offenses of sexual battery or sexual battery by one custodial position. Therefore, he had no news from those full count that he would be convicted of the lesser included offense. The fact that there were other charges of receiving molestation is irrelevant, as each count stands independently.
Counsel, I'm sorry to interrupt you. Can I ask you a question? Do you have any, is your entire argument based on per se prejudice, or do you have arguments that there, even if we accept the premise that we should do a prejudice analysis, that you could prevail on that?
Yes, so if you read this court's opinion in Prejudicial, it says you get to present reversible error by using the harmless error test. And basically, Your Honor, the per se reversible error is just a standard that says every time you do the harmless error analysis for a type of error, you always get the harmful error. So, for instance, like in this case, where the defendant was convicted convicted of a charge he did not go to trial on, which is a due process violation. That was going to be prejudicial. So, in my opinion, finally realized that harmful analysis were not always the reversible. You get the same result.
Okay, thank you.
The only other thing I would ask is that if you allow the GCA opinion to stand whereby the state can amend as far as after presenting the evidence or the wrong time to state is that they can wait to amend the information to fit the evidence at trial, and therefore nullifying the purpose of the information to begin with. If there are no other questions, I would like to reserve my remaining time for rebuttal.
Thank you. Counsel?
May it please the court, Virginia Harris on behalf of the state of Florida. I understood petitioner's argument to kind of go in two parts from her brief and some of her statements today. And I understood her argument to be that for the first part, that petitioner was prejudiced because he had claimed at trial that he could have potentially asked questions about the nature of the touching. And we don't agree. The record shows otherwise. The defendant's defense, even though he had already been charged with a count of lewd or lascivious molestation against each victim, he still came in and only argued that the victims had fabricated these allegations because they didn't like their stepfather, he was abusing their mom, he was a disciplinarian, and because of a specific fight that happened where the defendant was arrested. So that shows that he wasn't going to do that. In addition, the type of allegations we have here are not ones where you could make a credible argument that there wasn't lewd or lascivious touching. For the most part, all of the incidents occurred with the defendant going into the children's room at night, getting in their beds, putting his penis up against their butt, their anus, putting his hand on the vagina. There's discussion of his penis and their mouth, actually having sex with one of them, penetration, and there's many instances. Even though all three of the children were jointly tried, they were also similar fact victims, and the state also introduced other similar fact instances that weren't charged for some of the children. So it's very clear from these circumstances that if he did it, there was lewd or lascivious intent. There's no argument. This isn't a tickling incident from the living room where he says, wow, you know, I was tickling her and she turned the wrong way and I accidentally touched something I shouldn't have.
I'm just curious as to how far along the trial do you take the position that the state, under these circumstances, would have been permitted to amend the information?
Well,
Here was after directed verdict, correct?
well, it was at the part where they were talking about the judgment of acquittal.
Right.
And quite frankly, usually when the state does substantively amend a case, it's because there's been a factual development at trial, and they are worried about surviving.
So it actually, the defendant could have testified present evidence, rest,
Right.
and then
he-
the prosecutor could step up and approach the bench, Judge, now I'd like to amend the information to add this other element.
Well,
or change this element.
I haven't seen case law that.
Well,
let-
I'm asking how you think. What do you, how far do you think we can go, or you can go, in changing the elements of a crime?
Well, I mean, I guess based on the language in the case law, that it's as long as he's not prejudiced, but obviously if
Well,
you
what
went-
about it, let's say the jury comes back with a verdict, not guilty, can you change
No.
the elements at that time? Well,
Well,
why
it's-
not?
Well, it's
I mean,
over at that point.
Well, I mean, a directed verdict, if it's granted, is over.
No, I don't think the state, I think the trial would still have to be ongoing for the state to be able to admit. If it was actually submitted to the jury and they rendered a verdict, then
All
that
right,
would
so,
be.
okay, so let's say the end of closing arguments. Then the prosecutor steps forward to the bench, says, Judge, I'd like to change the information and the elements, and I'd like to change the jury instruction.
I don't think that the state could show that there wasn't prejudice under those circumstances, because you've changed the charges and he or she didn't get to make any argument on that. So I don't see how the defendant couldn't be prejudiced there. We're not suggesting that the state should be able to go around amending informations to change the charge at will. In fact, in many circumstances, the defense would be prejudiced. We're just saying under these circumstances, he wasn't prejudiced. And I don't actually disagree a whole lot with the other cases that were decided or mentioned by petitioner. I think this case is a unique set of circumstances. I mean, how often do you have a defendant already charged with 3 counts against each victim of the charge that's amended to, the lewd or lascivious molestation? How often do you have a case where you really just can't challenge the lewd or lascivious touching? You know that he wasn't going to challenge that. And then also in this case, you learn from his closing argument that it actually would have hurt his defense, because in his closing, he argues that the victims aren't credible. And one of the reasons he argues that is because they weren't detailed enough. So obviously he wouldn't have wanted to ask more questions to get them to give more details, because that would have derailed his defense. And I also would like to point out what took place when this conversation arose. There was a discussion about whether or not the state could amend these charges. The judge said, I'm going to give the parties 2 hours to think about this. If you finish sooner, contact my JA. They come back after 30 minutes, just a little bit more than 30 minutes. The state says, I want to amend these to molestation. The defense is not prejudice. The judge asks for a response. The defense attorney says, I'm going to object on the timeliness alone and leave it at that. He wasn't even going to argue he wasn't prejudiced. The judge then prods a little bit more, and he says, can you articulate any prejudice? And he says, well, I guess the only thing is there is this lewd or lascivious intent, and potentially I could have asked more questions about this touching. So he was really making a token objection here. And the standard is that you have to show the defendant's substantial rights were prejudiced. Well, was he really saying that? I looked up the word substantial, and it talks about great worth, importance, actually existing. If you say that a defendant is you're only potentially could have asked questions, is that actually existing prejudice? Because he's only saying that it's potential.
But isn't substantial, isn't that sort of a legal term of art for due process?
Yeah, I looked it up, and because your case law, Lacos and State versus Anderson, was done more in the 80s, I looked it up from the same Black's Law dictionary that I looked up the word substantive, which means essential or integral, and that is where I got the definition from. And so it's Black's Law dictionary, and I can supplement with that if you'd like.
Counsel, leaving aside a judgment of conviction, what about petitioner's argument that a lack of notice can in and of itself constitute prejudice?
I don't really agree that he was. I consider notice, and I think most trial parties do, as a practical matter. And in this case, the 4 counts that we're talking about, he was charged with sexual battery and 2 of the counts, and sexual activity in the other 2. And the acts were penetration or union with the vagina, penetration or union with the finger, that is, penetration or union with the anus with his penis, and then the other one is touching the anus or penetration, and then the other one is digital penetration of the vagina. So he was on notice of the sexual nature of the offenses. This court has even indicated in Ruffton that as a practical matter, the acts constituting capital sexual battery would include a lewd or lascivious molestation. Under these circumstances, you can't really have one without the other. It's like the First District stated, to prove the greater offense, the lesser of the, well, not the lesser included, but the molestation had to occur first. For example, technically, in the counts that allege digital penetration or union, union by the finger is not a capital sexual battery. So that allegation couldn't have been, even as it stood in there. There had to be penetration by the finger. So you would already know if that testimony came out that that would have to be changed. And in order to, based on these circumstances with these young children sleeping in the bed on their side, when he comes in to do these things, you cannot you can't penetrate the vagina without touching it first. You can't touch the anus with your penis or penetrate it without touching the buttocks first. These things had to happen in order for the greater offenses to occur, and that's one of the reasons that the First District distinguished this case from the other cases where the crimes were just changed. Something like fingers being changed to oral sex, where they're just completely changing the charge. In this case, it would just showed a lesser degree of touching. So in this case, we do believe that he was, and think about it for a second, just from a common sense perspective, and I know Justice Labarga was a defense attorney at one point. Imagine a defense attorney getting up in front of these jurors and saying, okay, the defendant did not do this. These stepdaughters made this up, but even if you believe that these acts occurred, they didn't demonstrate that he had a lewd or lascivious intent. I mean, you can't credibly make that argument under these circumstances. It's just not credible.
So isn't that somewhat his point, that if you have, that's your theory of the case, and that's what you're going with, but all of a sudden you have different charges, maybe you would have done something differently as a theory of the case?
But the only thing that he actually didn't even really say he would, he just said potentially. But the record shows that he wouldn't have. Because each victim, he didn't go through each count and say, well, what about here and what about here and what about...
But we really don't know, do we? Because it was changed. We don't really know exactly what he would have done.
Well, since it was done at the JOA stage, we do know, because he already gave his opening statements, and he's totally arguing that these girls fabricated what happened. We can see how he cross-examined the victims, and he never asked them any questions about the nature of the touching. And in reality, you wouldn't want to do that as a defense attorney. I mean, think about it. These victims, what happens with these sorts of cases is a lot of times the children have been abused for a long period of time, and there's a delay of reporting, and that's what happened in this case. Then there's the CTP interviews, and then 2 years later we have a trial. So these little girls are being asked to remember things that happened years ago. And they may not remember on any particular occasion whether he actually penetrated or just touched their butt. And so why would we want to let, under these circumstances, because the error and prejudice analysis are intertwined, you know, if there's prejudice, it's reversible error. We're talking about letting somebody go simply because a little child couldn't remember many years later whether or not he actually penetrated or not, when his defense was he wasn't prejudiced at all by this.
But in terms of the legal rule, I mean, what you're asking us to say is that the burden would be on the defense, instead of us kind of speculating as to could this or that have been different. They at least have to articulate
Right.
prejudice, and then the court can evaluate.
Right. And I really wish you, and I have that in my statement of the case and facts, but you would look at that. He wasn't even going to argue that. And it's because it's not credible. And that's probably why he argued that so meekly, because everybody that's down there with these type of allegations, you can't credibly argue that if they were done. I mean, what other questions are you going to ask? And the state asked quite a bit of questions about the nature of the touching. What other questions would he ask if about the touching under these circumstances to suggest that they weren't lewd or lascivious? He wasn't prejudiced at all. He was just making a token objection because, no defense attorney wants to be the bad person that didn't preserve the issue on appeal, and he doesn't want to get an ineffective assistance of counsel later. But the record clearly shows that he wasn't prejudiced. And then I'd also, if there aren't any more questions about that.
Isn't this essentially the same prejudice analysis that trial judges do day in and day out
Yeah.
under Richardson? The procedural prejudice?
It's very akin to a Richardson hearing, because what happens, the state hopefully inadvertently gives the defense some new evidence in the middle of the trial, and then he then has to say how he's procedurally prejudiced. In this case, after being told that he could have 2 hours to think this over, that's all he could say. Potentially, he could have asked these questions. And one more thing I want to mention is that when kids come out and they forget certain things about the testimony, the last thing that you want that favor you, the last thing you want to do as a defense attorney is go up there and start asking them more questions about the touching. You run the risk of having them remember or change their mind about what they said. That's not a good idea. And that's not what he was going to do. And I think you can look at this record and look at the way he presented his argument and see that that's not the case. It's not just that he wasn't greatly prejudiced. He wasn't prejudiced at all in this case. And then going to the second part where she says a per se rule should be applied. Well, I don't think a per se rule should be applied. In fact, I think per se rules should be limited to structural error. I mean, we have it's 924-33 where our legislature doesn't want us automatically reverse things. They want the defendant's substantial rights to be prejudiced. The language from this court's precedent for amending an information mirrors that. And I think that the language in DiGilio is very sound. When you're thinking about imposing a per se rule, then you should only do it in circumstances where it would always be harmful. And you have nothing to lose by not imposing a per se rule. If something is always harmful and it goes through a prejudice analysis, it'll get reversed. So nothing bad will happen. Whereas if you make this per se prejudicial, there will be a unspecified number of cases where the defendants are not prejudiced at all. And that would be an injustice. And we have, jury trials where judges and parties get ready for the trial. People have to get off of work to go in. It costs taxpayers lots of money. The victims, especially in cases like this, have to go through this ordeal. And so why are we reversing after a jury's found him guilty if he's not prejudiced at all? And like I said, in the normal circumstances, you determine if there's error and then if there's prejudice, and there would be a new trial. But in this case, there's no new trial. The defendant would, in this case, he wouldn't walk because there are other counts and there is a lesser included of battery. But in some cases, it could result in a defendant actually walking away. Petitioner is actually asking this court to engage in policy making that's inconsistent with that of the legislature. And I mentioned that I was hoping this court would limit per se to structural error. And I think that would make it easier for you, because the United States Supreme Court has very clear precedent on that. You don't have to follow them, but if you did, you wouldn't have to worry about running afoul to their case law.
Justice LaBarriere raised a point about, is there a point in time that you've gone too far to be able to change the charges? Is there a point in time where, okay, this has gone way too far, we've submitted this to the jury, and the charges should not be changed? What point in time or is there any point in time that's too late?
After it's gone to the jury, in my opinion, that would definitely be too late, because you've already made your arguments. How could a defendant not be prejudiced?
One would think. How about the jury instructions?
Well, it depends. Sometimes the judges give the jury instructions before closing arguments, sometimes after. I would think it would have to still be while the evidentiary portion was going on.
So I'm clear. Your point here is that after closing arguments, no more amending the information.
No more amending information.
So, and by the way, I was a prosecutor a lot longer than I was a defense lawyer. So let me sneak that one in. So that's your point. So once the lawyers get out there and argue, closing arguments, that's it.
Yeah, because how could a defense attorney not be prejudiced there if he's making his argument to a jury and all of a sudden the charges are changed? I don't see how you could possibly not be prejudiced.
But you're not asking.
Hang on a second. How about opening statements when lawyers get up and tell the jury, this is what I believe or what we believe the evidence is going to show? You're kind of, if you're any trial lawyer that attended all these courses you take to know how to try cases, they tell you that a lot of juries make up their minds after opening statements. And the thing is, you are basically making a promise, in a sense, without saying the word, to the jury. The evidence is going to show this, 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 and that. And then the defense lawyer gets up, the evidence is not going to show this, 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 and that. It's going to show this. Aren't lawyers at that point in time committed to what the charges are? At that point in time, you change the rules?
Well, no, Your Honor. First of all, juries receive instructions that informations are not evidence and aren't supposed to be considered as such. And the same thing about opening statement. But even in
the same thing can be said about closing argument.
But in regular trials, you have multiple counts, and certain counts are JO8 or reduced to a battery, and they go to a jury. And we're still allowed to do that. So why would that be any different?
Well, would closing arguments be any different? You said that you can't change the document after closing arguments. Lawyer makes closing argument. Why would that be different?
In this case, I believe he gave them the instructions.
Well, I'm talking about in general, because we're going to make a ruling here, one way or the other. In general, after closing arguments, how is that different than opening statement?
Because the evidentiary portion hasn't started yet. The defense can still, question his witnesses and decide what he's going to argue and what not. At that point, the trial's over. The evidentiary portion is over at that point.
But you're being led down this path. But I mean, the bottom line is, what we have to decide is, are you going to do a prejudice analysis, or are you going to do it per se? The point isn't to sort of speculate about other things where you might want to narrow or per se. The point is, all these kind of parade of horribles type things, it probably wouldn't be hard to show prejudice. You don't need to sort of lock yourself into these other types of things. I mean, it's either prejudice analysis or there isn't prejudice analysis.
Right, and in my view, your case law already says that. I mean, in the Clements case, the state actually added a whole nother charge. That's not just a change of an essential element, that's a whole bunch of new essential elements. And this court indicated that the trial court properly conducted a prejudice analysis and did not allow the state to amend the information. This court did not say it was per se error. But by adopting the structural error, limiting per se to structural error, you're getting the judiciary out of the policy-making business.
In this case, were the amendments before or after jury instructions?
They were before. But I don't think, like I said, it's not as though I'm arguing that the state should just have unfettered discretion to amend an information. There are many circumstances where the defense would be prejudiced. I mean, think about it. The defense attorney can argue that he is prejudiced in his investigation or in the nature of his defense. It's actually not that hard to argue your prejudice. It was just particularly hard under these unique circumstances. I don't think this happens a lot. I'm not sure.
Counsel, you're well over your time here.
Okay.
If you could sum up in about 30 seconds.
Okay. Well, if there aren't any more questions, we ask that you approve the decision of the First District and that you not impose a per se rule in this case. Thank you.
Thank you. Rebuttal.
So, as you heard, the respondent refers to the evidence at trial and refers to what the defense may have argued. That's not the right analysis. The analysis should be based on the allegation only within the 4 counts that were omitted. And you did allege prejudice. And the fact that you could not go back and ask about the murder of Thach. I will also remind you that you're holding Grosshans specifically says that Luke and the city's motivation is a separate and distinct offense from capital sexual value. So, it is a whole new charge because the serious element is the matter of touching. There are critical points that you need to pick up on is that the state initially agreed that it did not prove penetration on the 4 counts. When the defendant made the declaration, only after the 2 hours did the state come back and say, well, why would you amend the information to allege losing the serious molestation? I plead with you to go ahead and use harmless error analysis and respondent suggested. You come up with the same results. One client got convicted of the charge he did not go to trial. Now, the state has the power to amend the information as much as they want for this trial, but they have the witnesses. They have that power. The only time that power is limited is a trial. Therefore, we would argue to allow them to amend after the evidence would be to give them unfettered discretion to amend and to allow them to wait until they can amend to fit the evidence that came out at the trial. I urge you to reverse the 4 convictions and find my high-volume deeds prejudiced by the Midtrial